How can you streamline your custody case and maybe get a jump on it when you know it's coming? Well, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. You have to understand one thing about streamlining your case. There are two sides to the case. The case is going to take however long it takes based on collecting the evidence from both sides. So you can streamline your case. It doesn't necessarily mean it'll go faster, because if the other side's not equally committed to streamlining things and to moving things along, it might not likely happen. Having said that, you got to understand one thing. The court is going to establish a discovery phase during which time the parties get their information together that's necessary to prove their case. You can streamline your case by not waiting for that discovery phase and by getting together in advance those things that are going to be necessary to A, produce to the other side, and B, to help your lawyer prepare your matter. Now, in a custody case, for example, you know that the main thing we're looking for is what's in the best interest of the children. The court is going to take into account about a dozen factors that go to that. So because there are those factors, and because we're going to need evidence on each of those 12 factors, it would behoove the parties who want things streamlined and to move along quickly to get that stuff in advance to your lawyer. What does that mean? Pictures, videos, text messages, emails, those kinds of things that you think go to the qualification of the other side to be a custodial parent, the disqualification of the other side, things that go to your qualifications to be the custodial parent, things that might disqualify. You've got to get that to your lawyer, and since they're out there anyway, instead of waiting for the discovery phase, you want to get a jump on it, get that stuff to your lawyer in advance. It could be something that helps your case. It could help your case in the affirmative. It could help your case by being a negative for the other side. Whatever the case may be, get it to your lawyer. Get it sooner rather than later. It's going to be your lawyer's decision to say, you know what, this is interesting but not helpful. This thing that you didn't think was a big deal, I think it probably will resonate with the court. In other words, your lawyer is the best person to filter through that stuff. You may think that a picture of your ex holding a drink in his or her hand with a lampshade on their head means something. Well, it may mean something in context. It may not mean something. So, for example, if you're trying to show that in the middle of a regular work week, your ex drinks a lot, and here's a picture, it may show that. On the other hand, if the picture's dated, December 31st at 11:50 p.m., all it's going to show is that somebody's having a drink on New Year's Eve. That's not going to mean much to the court. For all I know, back in the background of that picture, the very judge who's judging the case might be having the same drink. None of that means anything. So, in other words, you've got to look at the context too. But my point is, if you get these things in advance, if you get these things together so that it can be analyzed by your lawyer, then you may very well assist in the streamlining of your case. If you have any questions about that, reach out. And of course, we'll be glad to help you out.